All right. Hello, everybody. How's it going? This is immigration attorney Mamita. I'm coming to you live to talk to you about immigration, including a very important policy update that you must know about if you are filing for VAWA or if you're considering filing for VAWA. I want to discuss this with you today so that I can help dispel any myths, set your mind at ease, and let you know what to expect. If you are filing for VAWA, one of the biggest, most important things that a lot of people ask me is, will there be an interview for VAWA? And up until now, there has never been an interview for VAWA, but as of last week, USCIS has announced that for the month of December, they will be issuing certain VAWA cases interview notices for the month of December in order to assess whether the persons who have filed for VAWA actually know that they filed for VAWA. So what does all this mean? Is this something that you need to be worried about? Should you be concerned? Should you give up? Let's talk about all that right now. So first of all, one thing that I do want to let you guys know is anyone who is worried about this new policy, take it down a notch, take a deep breath, and just let yourself know that it's going to be okay. An interview in front of an immigration officer is not the worst thing in the world, and it is not the end of the world either for your case. If you are filing a legitimate VAWA case, you have nothing to worry about. However, there are a few things that I want to explain. I want to explain, number one, what is the reason why USCIS has made this decision and this announcement all of a sudden out of nowhere, and what is really behind it, right? What is behind this decision by USCIS to give interviews in their VAWA cases? Well, number one, there have been some prosecutions by the Department of Justice of certain attorneys and non-attorneys who were committing serious and severe marriage and VAWA fraud. There has been at least one attorney who has been prosecuted and found guilty by the Department of Justice, who was filing, I don't know, maybe hundreds or thousands of completely fake VAWA cases where the person for whom he was filing VAWA was not even aware of the fact that VAWA was being filed. So in an effort to understand whether or not the applicants who filed these VAWA cases, whether they were complicit as part of the fraud or not, that is one of the reasons that I believe that these interviews are being given, okay? So that's number one. It's really to ascertain whether or not the person who has filed a VAWA application is aware of its contents, is aware of the basis of the case, and agreed to file the case by the attorney, okay? So that's number one. It is not some indication that you did something wrong by filing for VAWA. I want to make this very, very clear. VAWA has this really interesting reputation where a lot of people just automatically say, oh, if you're filing for VAWA, it's not real, which is completely not true. The law itself says that if you are married to a U.S. citizen, or if you're the parent of an adult U.S. citizen child and you have suffered extreme cruelty or battery in this relationship from that U.S. citizen relative, then you may be eligible to self-petition for an application underneath the Violence Against Women's Act. So first of all, let's talk about what is extreme cruelty, and what is battery. Extreme cruelty is something that immigration says is very, very broad. It includes a wide range of conduct that your U.S. relative may use against you in order to basically control you, in order to force you to do things, in order to have power over your life. It can include a variety of things, actions, it can include a variety of actions by your U.S. citizen spouse or by your U.S. citizen child that chip away at your self-esteem, right? So things where if your spouse or your child is calling you names, insulting you, telling you that you're a dirty immigrant, telling you that you know nothing, humiliating you in public, calling you stupid. It includes things that chip away at your self-esteem and what happens in that result is it causes you to basically do things out of fear because you don't have self-confidence, you don't have any more self-esteem left. It also includes psychological control, psychological harm. If you're being gaslit, if you're being manipulated. It includes things such as isolation. If your spouse or your child tries to control where you go, who you see, how you dress, how you control your money, and just generally how you live your life, these forms of isolation and control constitute extreme cruelty. Extreme cruelty also includes literally anything. It can include literally anything that the U.S. relative does to instill some sort of fear into you so that you basically do what they say, so you don't leave, so you don't, so you don't divorce, whatever it is, right? I'll give you an example that I was taught a long time ago. I don't remember if this is from a real case or not, but it's an example that I have been taught. There was a case that I was taught where there was a abusive husband who knew that his wife, when she was younger, would, their father or somebody would just pack up their clothes and put everything into a suitcase and put it outside the door whenever he was mad. So the wife was constantly in fear when she was a little child of upsetting her father and getting in trouble and getting thrown out of the house. And when she got married to this man, the man, after a fight, did the same thing, took all her clothes, packed it up, put it outside the door. What did that mean? That meant that the husband knew how to control his wife, and that was not a violent act. That was not a violent act at all. However, it constituted extreme cruelty because it was part of a pattern of coercive control trying to change and manipulate someone's life, right? So that is extreme cruelty. And if you file a VAWA self-application because you suffered any sort of these behaviors in your marriage, in your relationship with your adult child, then you have nothing to worry about. You filed a legitimate application. If you suffered battery by in the law, battery is defined as any sort of forcible, unwanted touch. It does not mean that you have to have bruises or broken bones. It could be slaps, it could be pushes, it could be scratches, it could be unwanted sexual contact, right? Unwanted sexual contact can also constitute battery. Having unprotected sex with your spouse where they're giving you STDs from somebody else can also constitute unwanted touching, right? These are things that the government itself considers to be battery, right? Also, acts of intimidation. If somebody acts like they're about to hit you, but they don't actually make contact, that's intimidation, that's aggression. That can also constitute a pattern of extreme cruelty. There's all sorts of things that the law itself says is considered extreme cruelty. So let's go ahead and read out loud some of what this new interview policy says, right? USCIS has the authority to request that any individual filing for a benefit appear for an interview. And if you receive an interview notice, you must follow the instructions on your interview notice. At your interview, you should be prepared to discuss your eligibility for a VAWA self-petition and your eligibility for adjustment of status. So first of all, USCIS is only giving out these interviews according to its announcement. They are giving interviews to persons who have filed both an I-360 and an I-485 and these interviews will occur during the month of December. And they have also announced that being selected for an interview does not necessarily mean that a deficiency has been identified in your case, nor does it alter eligibility requirements or applicable evidentiary standards, okay? However, failure to appear at your interview if you have received an interview notice may result in a denial of the VAWA self-petition and application for adjustment of status, okay? Let's go ahead and talk about what this means. Number one, what I want you to understand that is if you get selected for an interview during the month of December for your I-360 VAWA application, it doesn't mean anything about you. It doesn't mean anything about you. You've been selected in random. So far, I have received only one interview notice out of all the cases that we have pending right now, okay? I have only received one interview notice. We might receive more, I don't know, but I know other attorneys who have received more. But just to give you an idea, it's not like they're going to be giving these interviews to every single person. In fact, I want you to keep in mind how busy immigration offices are and how busy immigration officers are, and the fact that they already have to conduct all of these other interviews. They have to conduct all of these other interviews for marriages, for marriage green card cases, for I-751 applications, for N-400s. They're already really packed to the gills with interview, and that is why sometimes you might be waiting months and months for your interview in your marriage case or for your citizenship application, right? So the fact is that even they will not be able to give interviews to every single person, and they probably will not be able to give interviews to even half or even the majority of cases because of the time limits that they have in their cases, right? So just by the mere fact that there is limited interview availability. Not everyone is going to receive an interview appointment. Next, what does it mean that you must be prepared to discuss your eligibility for VAWA? So number one, the most important eligibility for VAWA is you have to prove the number one is your qualifying relationship. So if you're filing for VAWA as a spouse or as a parent of a U.S. citizen, or if you're the child of a U.S. citizen, you have to prove that you have a qualifying relationship. Usually we prove these through divorce certificates, marriage certificates, or birth certificates, okay? Number two, you also have to show that you have been subjected to extreme cruelty or battery, right? So how are they gonna ask you about this? How are they gonna ask you about this, and how are you going to talk about extreme cruelty? Well, as I've mentioned, there are many things that constitute extreme cruelty, right? The most important thing is to describe how your life was turned upside down. And really, I really urge you, if any of you out there are without a lawyer and you get called in for a VAWA interview, please seek legal help. Please have an attorney accompany you, and please have an attorney assist you with your interview. For me, I have had lots of experience with I-751 extreme cruelty and battery waivers, which are basically talking VAWA, because in an I-751 application where you are seeking a waiver of the joint filing requirement due to extreme cruelty and battery, basically you have to show what is underneath VAWA. You have to show that you suffered extreme cruelty or battery or both from your U.S. citizen spouse. So when you file an I-751 application requesting a waiver due to extreme cruelty and battery, and they call you for an interview, which these days, roughly, I mean, almost all of my applications are getting interviews for the I-751. You have to be prepared to talk about abuse, okay? You have to be prepared to talk about abuse, and there are some ways that you have to talk about it to demonstrate to the officer exactly what you suffered and how bad it was. I'm not going to go into all of that right now, because abuse is very, very individual. Abuse is very, very specific. But let's just talk about it this way. Immigration officers, some of them have a lot of training, some of them don't have a lot of training. So what are the things that are going to be obvious sorts of abuse to them? Well, anytime you're being controlled, not allowed to leave the house, not allowed to work, not allowed to talk to family, anytime you are physically hurt, anytime you are threatened with deportation. These are usually the things that are the most recognizable types of extreme cruelty. And of course, battery is going to be if you have suffered, marital rape, unwanted sexual contact, actual physical abuse. Now, one more thing that the new announcement says is that this interview does not mean that evidentiary standards are changing. This interview notice that you may receive does not mean that evidentiary standards are changing. So if you get a notice and you freak out because you're like, oh my gosh, I have no proof of these things, please take a step back, take a deep breath, and remember that the law says that the evidentiary standard for a VAWA self-petition is any credible evidence. And any credible evidence is going to include your testimony at the interview, okay? It's going to include your testimony. So they are not going to decide your VAWA, but rather you have to demonstrate that you are eligible for VAWA, right? So you have to show that you know the contents of your application. You have to be able to talk about your abuse if they ask about it. And keep in mind, we don't know exactly what they're going to ask about. We don't know exactly how these interviews are going to go. And I will, of course, come back here and explain more, from our experiences and share with you like what I learned, so you can feel better and you can feel more prepared, okay? And the last thing that I wanted to share is that these interview notices, USCIS has announced that this is something that they are doing temporarily. They plan to do these interviews during the month of December. I believe that they have announced that they will only do this during the month of December. So if you don't end up getting an interview notice in December, there's probably a good chance that they're not going to call you in for an interview on your VAWA application. And they're going to reassess, right? They're going to reassess to see whether they need to do it. Now, what are two potential outcomes from this? Number one, they might reassess and say, you know what, we don't really want to spend the time, we don't want to spend the resources to do these VAWA application interviews. So we're just going to go back to the normal way and let the Vermont Service Center process these applications and decide whether there's VAWA eligibility. So they may say that they're not going to do anymore, right? But what happens in case they say that they are going to make this part of the permanent process for interviews? Well then, guys, we're gonna suck it up and we're gonna be fine. We're gonna go for it, right? Because if you qualify for VAWA, you have nothing to fear. One of the biggest things that people say to me is that they are afraid to file because they feel like they don't have enough case. And one of the things that I want to point out to you is that one of the things that I want to say to you, that I want you to get really clear about, is the fact that your belief that your case may not be strong enough is not the same as filing a case that is not right to file, right? You have the right to file because if you have suffered anything and you have a good faith belief that you suffered in your marriage, in your relationship, and that you may qualify for VAWA, even if the government says no, that doesn't mean you did anything wrong, right? People file for applications all the time. If you have a good faith belief that you should qualify for VAWA and that's why you're applying, that is amazing. That is great, and you have nothing to worry about. If you file for VAWA knowing that you're not even married to somebody, that you're not even, that you're not, you never, that you don't even qualify for VAWA at all, right? Like if you file VAWA in actual bad faith, trying to game the system, that's a different story. And anyone who does that with any sort of immigration application may have to face the consequences in the future, right? So that sort of fraud is not limited to just VAWA. There are plenty of people out there who are possibly doing marriage fraud, asylum fraud, and things like that. So it just exists in every area, okay? And to any of my clients that are watching, again, I want you to take a deep breath. Take a deep breath and just know it's going to be okay. You've got us on your side. You've got me and all of our attorneys at the Rahman Law Firm. We are prepared. We know how to do these interviews. We know how to conduct ourselves, and we know how to handle officers. And at the end of the day, we are here fighting for you. And that's what you need. You always need to have a lawyer by your side who's going to fight for you, whether you have an interview or not, okay? So that's what I wanted to explain about these VAWA interview notices now that it is a reality and we are starting to get our first notices. To recap all of this, the reason why USCIS has announced this change is because they basically want to find out whether people know that they're filing for VAWA, right? They basically want to know whether you know that your case is a valid case, because there has been a lot of fraud that has happened where some attorneys file VAWA for people without the person ever even knowing that they filed for VAWA. Now that's a bad faith application. And the reason why USCIS wants to determine whether you know for it or not is because if you knew that you never qualified for VAWA and you let the lawyer file for you, then that may be a problem. But if you believe that you suffered, believe that you're eligible, even if you don't think that your case is strong, that is not the same as filing a bad faith case, okay? Number two, they have announced that this is just for the month of December and that they are going to reassess whether they will continue to have more interviews. And number three, if you are going to end up having an interview in December, probably by now you've received your interview notice, or you will receive it in the next couple of weeks, okay? So that is what I wanted to share with you. Let's go ahead and answer some questions. I just want to do a temperature check that everybody's okay. I don't want anyone to hyperventilate or get freaked out. Just remember, I have explained to you the eligibility requirements, and that's what the law says. That's what the law says, okay? If you want to file, if you want to see if you qualify, give our office a call, 212-248-7907. Okay. Alejandra, thank you so much. I really appreciate it. Alejandra says, I have started my VAWA application with you guys, and I feel very confident in your ability to help me with the progress. Thank you for the clarity in your videos. It's my pleasure, Alejandra. Thank you so much for deciding to work with us. And we really hope we will meet every single one of your expectations, okay? Can the immigrant wife and mother-in-law in the same household file for VAWA based on abuse by the U.S. citizen spouse or son-in-law? John, okay, I think you're asking two things. If the mother-in-law suffers abuse from the son-in-law, can they file for VAWA? No, because the mother-in-law does not have a qualifying relationship, and the only qualifying relationships that are allowed are being the spouse of a U.S. citizen, or being the spouse of a green card holder, or being the parent of a 21-year-old U.S. citizen child, or being the child of a U.S. citizen or the stepchild of a U.S. citizen, okay, underneath 21. If you're a mother-in-law and if you yourself are living in a house with an abusive person who happens to be your son-in-law, that son-in-law does not, that relationship is not qualifying for VAWA. However, if you are living in a house where your son-in-law is abusing you, If you're living in the same house as somebody who's abusing you, but you're not married to them, it doesn't matter what the family relationship is. If you're not married to them and they're abusing you, they're forcing you to work, forcing you to cook, forcing you to clean, they threaten you whenever you don't do what they say, these may be grounds for something called the T visa. And if you have ever suffered actual violence and you've gone to the police or called the police because of what they have done to you, then you may qualify for a U visa as well, okay? Give us a call, 212-248-7907. Vishnu, you change from F1 to green card and you're unable to get your I-94. If you have a green card EAD from Vishnu, if you can't find your I-94, it's going to be fine. You can always apply to get a copy of it from CBP, or you can look electronically, or I don't think it'll be an issue, because if you are filing for VAWA, you don't need to prove a legal entry anyway. Okay, so I don't really foresee that being a problem. Can Trump stop the T visa process? My T visa application was filed in June. Good question, Mary Shane. Mary Shane, the T visa is based upon statutory law, which Trump, any president, no president, doesn't matter who it is, no president can affect statutory law. The statutory law itself has to change, which requires amendments through Congress. It requires a vote and all of those things. And those are not things, those are things that Trump can ask for and for them to start, but I don't believe that he'll be successful. And also, it's nothing that would ever happen instantaneously. It's not like it's going to happen the first day he gets into office. If it, let's say, God forbid, it were to happen, maybe it would probably take some years. So that's another reason why, if you qualify for something, get your applications in now before, who knows what's going to happen. I'm holding out hope that things are going to not be as bad as people say. I'm also holding out hope that even if there's a lot of craziness in the first few months, eventually when the dust settles, it's going to be fine. But let's just say worst case scenario happens, right? And we truly have some crazy stuff going on and they try to change the laws. Well, like I said, the laws take a long time to change. Get the applications in now before it does, okay? All right, let's see. I'm in Jamaica and I filed for an I-601 waiver for misrep. How long does it take? From Puzi, grateful Puzi. I would say that I-601 waivers can take about 2 to 3 years to be processed. Are you looking for paralegals? Yes, I am, from Mamita Rubita. Mamita, go look on our website. You'll see careers with us link to Bamboo, and it'll show you all of our open positions. And we are hiring for paralegals in New York. Okay, so please reach out to us, Mamita. Is there interview for anyone who filed for VAWA in October of this year? We haven't seen so far. I believe that they're giving out interviews mostly for people who filed in April and May. Can persons who have criminal charges and who have deportation apply for VAWA from RID 1? RID 1, it depends on what if you have a criminal charge, whether or not you can file for any immigration relief depends on what the charge was for and what sort of case you're applying for, and whether you need a waiver or anything like that. So everything depends. If you have any sort of criminal charges, you need to get your documentation so that the lawyer can analyze all these things. If you have a deportation, can you apply for a VAWA? And the answer is yes. Deportation does not prevent you from filing for VAWA. Although if you already have an order of deportation and you're filing for VAWA, you're not going to be able to get your green card until the VAWA, not only does the VAWA have to be approved, but the court has to reopen your case in order to allow you to do your green card application. So it's going to add several years to your process if you already have a deportation order. But once you get VAWA approved, you also get something called deferred action, and deferred action protects you from being deported. So even if you have a deportation order, the deferred action is going to help you, okay? All right, let's see. How to waive a 10-year ban from Amy? That's a good question. And Amy, I don't know why they hid your comment. How to waive a 10-year bar. Okay, how can you waive a 10-year bar? So first of all, the question depends on what kind of 10-year bar it is, because there are actually two types of 10-year bars. There's the permanent bar, which is what I call like the hard bar. It's the much more severe penalty. And then there's the regular 10-year bar, which it's not the same. And if you have the regular 10-year bar, the way to fix it is either through something called you can waive it through the I-601A waiver for unlawful presence. You can also just stay outside the country for 10 years. If you have the permanent bar, you can waive that through the T visa, the U visa, asylum. You can also possibly waive it through VAWA as well. Okay. Now, if you get the 10-year bar and because you've left the U.S. and you come back to the U.S., sometimes being in the U.S. for that period of time may also count towards the 10 years that you have to wait. Thank you for the follows. When can I apply for my citizenship after getting my green card from VAWA in 2022 from Muncie? Muncie, once you get VAWA approved, if you get it through marriage, then you can apply for citizenship after 3 years, okay? So if you got your green card in 2022, then it sounds like 2025 is roughly when you can apply, but always consult with the lawyer because sometimes, you have to make sure that there's no other factors that would prevent you from filing, okay? Or getting approved. Keeping families together and is dead and I-601A is not an option for me. What else can I do to get a green card? From Pavme? Great question. So what are your options now that keeping families together, the Biden parole in place is dead, right? It's gone. If you are counting on that and you don't want to leave the US and the I-601A application is not an option for you, you have to reassess to see whether you qualify for anything else that would allow you to stay here in the U.S. without leaving. These applications, people don't like to hear it, but if you were trying to do keeping families together or I-601A because you're married to a U.S. citizen, I just have to ask you, what are you suffering? What problems are you suffering in your marriage? A lot of people, I really hate to say it, but a lot of people suffer the level of problems that may qualify them for VAWA. So it's something that you might want to start wrapping your head around, because what you're going through in your marriage, if you are going through some problems in your marriage and they rise to the level of extreme cruelty or battery, then VAWA may be an option for you, which would not require you to leave the U.S., right? Number two is we can look to see, if you don't want to go down that road, but you don't want to leave the U.S. to get your green card, we can look to see if you qualify for a T visa. Now, as a recap, the T visa is something so many people qualify for and not enough people know about, and not enough lawyers know how to do the T visa. And that's just a damn shame, because the T visa is going to be anywhere where you are forcibly made to work, right? You are forcibly made to work underneath threat, underneath fear. If you work for somebody who basically you were scared to not listen to because you were afraid of them reporting you, you were afraid of them harming your reputation, you were afraid of them causing you some other sort of injury to you or to your family members if you don't listen, if you don't comply, then the T visa may be an option for you. And the beautiful thing about the T visa is that it may also apply to anyone that you have a domestic relationship with, a family relationship with. And I'll give you some examples. If your uncle and aunt brought you to the U.S. and then once you get here, they make you become their servants, live in the house, live in the basement, cook and clean all day, they don't let you out. That's probably a T visa. If you're in a relationship with somebody who, they wake you up out of bed, no matter what time of night it is, make you cook, and if you don't listen to them, they beat you, they hurt you, they won't let you out unless you do certain sexual acts with them. That may be a T visa, right? There's so many circumstances underneath which a T visa may qualify. Only way that you're going to find out what you're eligible for is to do a case evaluation with the right lawyer to try to unturn every stone. What we say here at the law firm Mamita Rahman is that we endeavor to leave no stones unturned, because we want to make sure we uncover every opportunity and option for you to stay legally here in the U.S., okay? And if you want a case evaluation with us, call us 212-248-7907, okay? My name is Mamita Rahman. It has been my pleasure to be here with you today. Thank you so much for the shares, for the follows, for the likes. I really appreciate it. I will see you again next time, and happy Thanksgiving in advance to all of you. I hope you get to be with your loved ones. I hope you get a little time to rest. And, I wanted to let you all know how grateful I am to each of you who are watching me right now for giving me this opportunity to talk to you from my heart, to talk to you about these cases. And to my clients, thank you for letting me be your attorney, okay? Have a really, really wonderful night. Thank you and God bless.